everyone. I'm Maya. I'm a project manager and cluster lead on business and human rights, as well as sustainability in supply chains at econsense. I'm based in Berlin and Germany, and I have the pleasure of introducing you to the topic of business and human rights. But first of all, I want to introduce you to the organization I work for. We're a network of currently 51 big German companies, some of the brands you might be familiar with. We're cross-sector, and our goal is to actively shape the change to a more sustainable economy and society. A quick note on how we work. We track and analyze all relevant topics from biodiversity to climate to human rights, everything that is relevant for corporate sustainability. We support our members in anchoring sustainability in their operational practice, in their strategy, but also along their supply chain. And we are a platform for high-level and expert dialogue, so the companies can exchange peer-to-peer, but we also exchange with business, with other business, politics, and civil society. Today's agenda consists of 6 chapters. I will give you a quick introduction on business and human rights, and then we will dive deeper into international frameworks on due diligence laws, mainly in Europe and Germany. And I will then give you an overview on human rights due diligence, measures you can take as a company. We're going to further look into reporting on human rights and into KPIs and quantitative indicators that you could work with. And finally, I will present a few case studies about industry examples on due diligence in practice. So let's get started. Human rights constitute a basic value for business enterprises which operate with integrity. Hundreds of multinational companies have either an explicit human rights policy or they refer to human rights in their codes of conduct and compliance monitoring. While protecting human rights remains the duty of countries that have ratified international conventions, the Universal Declaration of Human Rights declares that every organ of society, including companies, must promote respect for those rights. Companies can have an impact on human rights in a number of ways. Labor practices, host government relations, and community engagement all have the potential to enhance or threaten the freedoms and livelihoods of nearby communities. Incorporating human rights into all of these areas can provide a framework for cohesion and stability and lasting relationships with the people you rely on to run your business successfully. So let's have a look on 4 reasons why human rights matter to companies. There's one reason that is regulation. Countries throughout the world are passing laws regulating conditions in international supply chains. Governments are under pressure to regulate an increasing number of social issues, both domestically and internationally, from human trafficking to environmental damage. And companies need to prepare themselves for or comply with these regulations. And above and beyond these legal obligations, there are also a number of other reasons why your company should incorporate human rights into its policies and procedures. There's reputational risk. In April 2013, the Rana Plaza garment factory in Bangladesh collapsed, killing more than 1,300 workers. And this incident did not simply serve to demonstrate the extremely poor working conditions that persist around the world. Many very well-known companies which used Rana Plaza as garment production plant were also held directly responsible for the collapse and were regarded as complicit in the lack of fire exits and manager abuse that had contributed to the death toll. Then there's consumer and investor pressure. It is not just governments that are expressing increasing concern over business-related human rights violations. Consumers increasingly expect transparency and ethics in supply chains, from organic food production and fair trade clothing to renewable energy. And consumer advocacy campaigns indicate that these issues become salient for consumers as soon as they are made public. Investors are also demanding that companies define the scope of their non-financial risks. Institutional investors are under more and more pressure to rid their portfolios of fossil fuels. The growth of socially responsible investment in recent years has been explosive. Export credit agencies are also expanding their criteria for social risks. Consumers and financiers are increasingly asking companies questions about their impacts on society, and companies which target sustainability should be prepared to answer them. And then there's the long-term value creation. The previous points, 1, 2, and 3, explain why human rights should be respected, but in a negative manner, since they detail why your failure to respect these rights will result in unfavorable consequences for your company. However, the strongest argument for human rights is the fact that many positive benefits will be created for your company. Because when you establish constructive relationships with your workers, suppliers, customers, and communities, that in itself will unlock the full potential of your sustainability, growth, and productivity. The increasing pressure on companies to manage their social impacts has yielded innovative approaches and programs. From suppliers' capacity building to town hall meetings with communities, companies have found that respecting human rights is not simply a risk to be managed, but an untapped source of innovation. Human rights may seem like a complicated legal and technical field that will impose a new, unbearable, formally state burden on your company. However, you are already performing a range of activities such as occupational health and safety programs, anti-bribery rules, and environmental standards. And all of these are directly associated with your human rights obligations. Your fundamental responsibility under human rights is to consolidate these efforts and build relationships with your workers, suppliers, and customers that facilitate the issues rather than complicate them. The relevant question here is not, can I afford to respect human rights? It should be, can I afford not to? So the next section will cover theoretical approaches in the form of frameworks, and those build the foundations for human rights in business. So now we're moving over to international frameworks and foundations for human rights in business. And this section will cover theoretical approaches in the form of frameworks, and those build the foundations for human rights in business. 1948, a crucial year for the State of Israel, and also the year the Universal Declaration of Human Rights was introduced. Put simply, human rights are a set of rules that define how people should be treated. They include rights related to political participation and liberty, like the right to equality, the right to participate in government, or the right to free speech, and rights related to quality of life and well-being, like the right to work, the right to food, or the right to health. These principles are defined in the Universal Declaration of Human Rights and have been further elaborated in legally binding conventions. In addition to the fundamental rights laid down in international human rights treaties, the labor standards of the International Labor Organization, ILO, set universal minimum standards for decent work. And for the first time, the context of work was put into focus in such conventions. In the ILO Declaration on Fundamental Principles and Rights at Work, all ILO member states have agreed to respect these areas set out in the ILO core labor standards. On the left side, you see the 5 core principles, such as elimination of forced labor or the abolition of child labor, which were translated into 10 conventions that you can see on the right side. There are conventions on occupational safety and health, freedom of association, but also on equal remuneration. The ILO core labor standards are ratified by states. So for a long time, it was unclear what role companies play in protecting human rights because they were still not addressed, even though we're talking about the context of work. To close this gap, the UN Guiding Principles on Business and Human Rights were adopted in 2011 and address the responsibility of companies when it comes to human rights. They were developed with broad participation from private and state actors. And the three guiding principles were formulated under the heading Protect, Respect, and Remedy. And with regard to respecting human rights and the conduct of business, the UN Guiding Principles are the most important source, as you will see later on when we talk about due diligence in practice. So let's walk through the three pillars. First is the state's duty to protect human rights. Each state has an obligation to set the political and legal framework for business and investment to ensure the protection of human rights and labor standards. Second, corporate responsibility to respect. Corporate responsibility includes taking reasonable precautions to avoid human rights risks within the corporate sphere of influence. And the third pillar addresses rights holders and gives them the right to remedy. So people whose human rights have been violated by companies must have access to effective remedy. Another framework which is mentioned and referenced a lot in the context of business and human rights are the OECD guidelines for multinational enterprises on responsible business conduct. It's a globally valid code of conduct that gives recommendations from governments to business. The OECD guidelines regard due diligence as an ongoing process of systemically and proactively identifying risks and potentially negative consequences for corporate social responsibility. It is not only about human rights, but covers even more topics such as corruption, environment, taxation, as you can see on the right of the slide. The document has been revised since the 1970s, and the most current version is from 2023 and references the UN Guiding Principles. So as frameworks, the UNGPs and the OECD guidelines are recommendations, so they are not binding. These documents explain how companies can meet their responsibility, and both frameworks are interoperable, which is very important, and you'll see later on in the section of due diligence in practice. The Principle 17 of the UNGPs, you see on top of the slide, references due diligence. And this is what is visualized by a concrete process, as you can see here on the center left of the slide. The OECD guidelines define due diligence as the process enterprises should carry out to identify, prevent, mitigate, and account for how they address these actual or potential adverse impacts in their own operations, their supply chain, and other business relationships. We linked the documents, and I will get back to this due diligence process later on when we talk about practice. The next section will cover due diligence laws on European and German level. Now we're moving from soft law and frameworks to hard law. So let's have a quick look on Europe, or to be more exact, on the European Union. You see here in blue, Germany, as one member state of the European Union, introduced its Supply Chain Due Diligence Act already, and the European Union is currently working on a similar one that would be applicable to companies in all EU member states, from Portugal to Finland. So let's have a closer look on the legislation. The German law entered into force in the beginning of 2023, but it is important to know that it is currently being revised. It is applicable for companies with offices in Germany and with more than 1,000 employees in Germany. The companies have due diligence obligations, as you just saw in the OECD cycle, full obligations for their own operations and for their direct suppliers, and limited obligations for indirect suppliers. They also used to have a reporting obligations, so they had to publish a report annually, but this is also part of the revision that is currently going on. There was also a very strict monitoring and sanction scheme that is also currently being revised, and there's no civil liability foreseen in the German Act. In the European Corporate Sustainability Due Diligence Directive, the status is currently in negotiation. Most likely, it is applicable for companies as of summer 2029. And it is applicable for big European companies above 5,000 employees and 1.5 billion net turnover per year. Very important to note at this point, it will also be applicable for non-EU companies who make more than 1.5 billion euros net turnover per year on the European market. The due diligence obligations are pretty much the same as the German Act, and there will be a sanction scheme with a maximum cap of 3% of the company's net worldwide turnover. There will be no civil liability regime in the European Union. This will be the task of the member states to put into effect. Important or interesting at this point is to see how many companies have to comply with this law in Germany. So currently, with the German law, it is 5,000 companies. In Europe, with the European legislation, it will only be 1,000 companies throughout the European Union. We talked about the Declaration of Human Rights and internationally recognized conventions. Here you see the human rights conventions, so rights and prohibitions that companies need to consider when assessing their impacts, which are applicable in the German and the EU law. So we're moving from fair wages over child labor to forced or compulsory labor. As you can see, there's a multiple topics addressed in those laws. Besides human rights, there are also environmental conventions. Both laws require companies to take into account when assessing their impacts. You can see we're talking about persistent organic pollutants, we're talking about mercury or the disposal of hazardous waste. And actually, as of right now, it is for most of those conventions not clear how companies can take those conventions into considerations when it comes to their due diligence measures. The next section will cover due diligence laws on European and German level. So now we're moving from theory to practice a bit more, and we'll look on human rights due diligence processes and measures. The process of identifying and mitigating your risks and impacts is known as human rights due diligence. As in this case, with other due diligence processes your company undertakes, human rights due diligence does not require you to have a perfect record overnight. It should, however, be an ongoing process. Regardless of your company's size or complexity, the important element here is to establish communication channels with the people who are affected by your operations and to leave those channels open for an ongoing dialogue. The second key principle is your degree of responsibility for the impacts your company has on human rights. Some human rights issues, such as those related to working conditions in your own factories, are within your own control, and consequently, you are responsible for correcting them. Other impacts, however, like working conditions in your supplier's factory or the actions of governments in the country in which you operate, are not so easily remedied, requiring collaboration and further action on your part to rectify the situation. Reducing workplace accidents or achieving legal compliance requires dedicated staff, adequate resources, and careful prioritization and strategy. Human rights due diligence is not a one-off activity. It is a permanent and continuously active component of your business. So considering your company's risks in a systematic way, you should, 1, know your workers, 2, know your suppliers, and then know your human rights impacts. Taking action on human rights doesn't mean changing everything about your business. In the short term, focus on quick wins to improve your workplace. In the longer term, work with other companies in your sector or region to improve conditions in your supply chain. Many of your own customers will be eager to help you take the first steps. There are various standards, tools, networks, resources, and civil society organizations that are able to support you. This process or wheel of 6 steps you recognize from a few slides before, it was published by the OECD and helps meeting your company's responsibilities towards human rights. The process consists of first, in yellow, the embedding responsible business conduct into policies and management system, identifying and assessing adverse impacts, seizing and or preventing adverse impacts, track the implementation and results, communicate, and in case adverse impacts come into place, you have to provide for or cooperate in remediation when appropriate. And I will now guide you through all of those steps and touch upon supporting measures and questions you can consider as orientation. So, first step, and again, it is important to note at this point that as the UN Guiding Principles are the most common framework on business and human rights, I'm referencing them a lot. So here I'm referencing, for example, number 16. While embedding responsible business conduct, you should think of policies and management systems. When it comes to policies, you should involve your board for approval, work with internal and external experts to include their valuable information, communicate your expectations of personnel, your business partners, and others, make your statement publicly available, and reflect the commitment in other operational policies and processes. Another aspect while embedding responsible business conduct is your management systems. Those are relevant questions on how to anchor human rights in your company. You can consider them while evaluating the status quo of your management systems. So you can ask yourself, what are the company's values? How are they put into practice? Who should be involved? Which departments are relevant for conducting human rights due diligence? What information is necessary? What information is already available? And where do you find it? Who is responsible? And how is this person or department positioned within the company? Is there any indication of how well processes and measures are working to manage risks to people and where they may have weaknesses? What opportunities for improvement are there? And lastly, where would it be placed within the organization? Speaking of where would it be best placed within the organization, I brought an example on which persons and departments could be involved in human rights diligence. The overall responsibility should lie within the executive board. We've seen different setups like the CHRO in charge or even the CEO. For monitoring and controlling activities, you can appoint, for example, the head of sustainability, the head of compliance, and then other departments like human resources, purchasing, legal could be involved. Usually they participate in an overall team taking care of managing human rights within your company. Now we're coming to step number 2, identifying and assessing adverse impacts. The UNGP state that in order to gauge human rights risks, companies should identify and assess any actual or potential adverse human rights impacts with which they may be involved either through their own operations or as a result of their business relationships. And while doing so, you should draw on internal and external human rights expertise. The assessment of impacts, sometimes also called risk analysis, should be done on a regular basis. A year can be a good orientation in case you have a big merger, acquisition, or an additional product in your portfolio, and a TOC analysis can make sense. Because there are multiple ways of conducting an impact assessment, here you find a schematic process with 6 steps. So A, you should determine the scope of your assessment and plan the assessment. B, develop an assessment methodology and plan stakeholder engagement. C, collect data. D, analyze this data and prioritize issue areas. E, define and implement follow-up actions. And F, monitor the compliance, communicate performance, and reassess if necessary. Step 3 is preventive measures. So if potential adverse impacts have been identified, should have been identified, or if a substantiated complaint has been transmitted, here you can find examples of measures that you can put into place. For example, and this is in no particular order, a preventive action plan, a code of conduct for your own employees and for your business partners, trainings for own workforce and for your suppliers, specific contract clauses, controls and audits, and a supplier selection strategy and process. Step 4 is tracking implementation and results. So tracking implementation and results should be based on appropriate qualitative and quantitative indicators. It should draw on feedback from both internal and external sources and be integrated into relevant internal reporting processes. The tracking should also focus on the effectiveness of measures. So that means that procedures for regularly reviewing the success of the measures should be taken, monitoring the relationship between measures and impact, and measuring the progress of the company's efforts. And for measuring the progress or even impact, you can formulate an effectiveness hypothesis when designing the measure, like, for example, the input, output, outcome, and impact method. Develop qualitative and quantitative indicators when designing the measure, and after or during the measure, review by applying the indicators. And the goal is to continuously improve your due diligence processes. Step 5, communication. So how to address your impacts. The communications should be of a form and frequency that reflect the business human rights impacts. It should provide information that is sufficient to evaluate the adequacy of the business's response, and it should not pose risks to affected stakeholders, to personnel, or to any legitimate requirements of commercial confidentiality. The communication can take a variety of forms. I just put a few examples here. It can be in-person meetings with your board. It can be online dialogues with stakeholders. It could be a consultation, formal public reports like annual reports, and so on and so forth. And an independent verification of human rights reporting can strengthen its content and credibility. The communication eventually helps provide transparency and accountability to individuals or groups who may be impacted and to other relevant stakeholders like investors. I brought a few examples here. This is the integrity code of Mercedes-Benz, an automotive company. And they have analyzed a few of their impacts. One of them is health and safety. And they formulate and communicate their compliance with health and safety standards and their expectations to their own employees. Another example is this you can find on this slide. A voluntary progress report of Lidl, a big supermarket chain in Germany. They are informing external stakeholders about their impacts, standards, projects to expand fair trade, and their commitment towards human rights, especially in their supply chains. Step 6, and the final step within the due diligence process, is remedial actions. So if actual adverse effects have been identified or should have been identified, or a substantiated complaint has been transmitted, active engagement in remediation by itself or in cooperation with others is demanded. And the following measures are examples that you can use as remedial action. So that would be the neutralization or limitation of adverse impacts and corrective action plan, the adjustment or improvement of business plans, strategies, activities, such as your purchasing practices, the design and distribution practices. One measure could also be the temporary suspension of the business relationship or the termination as a last resort, and eventually remedy in the form of a financial remedy. The next section will cover challenges in conducting human rights due diligence. So, human rights due diligence is not an easy task. This is something I cannot stress enough, and you'll encounter some challenges, and I will guide you through those challenges. Companies are facing challenges when it comes to human rights due diligence. And as you can see on the two wedges in the slide, there are two forces pulling in different directions. In the area where a company often has a lot of influence, like their own operations, the risk of human rights violations is often smaller. And in the area where you have less influence as an individual company in the deeper supply chain, the risk is probably always greater. So we see a lack of leverage as one challenge, also because human rights risks may be caused by structural problems in the state companies are operating in, which cannot be solely addressed by an individual company. Therefore, collective action or political support through trade and development politics is needed to stress respect for human rights. Measures which can be taken are therefore depending on three areas: own business unit, suppliers, and deeper supply chain. Another point is that the mapping of global supply chains is very complex. Large companies may have a huge amount of direct and indirect suppliers around the globe. Their supply chain networks are dynamic and in some part lack transparency. Who buys from whom is not always clear. Adding to that is the complexity of data. There's a lack of uniform method of measuring social issues and human rights risks, and hence to manage them. Besides systematic challenges, it is possible you'll encounter also organizational challenges within your company. For example, no common vision when it comes to human rights in your company. You may encounter silo mentality and resistance to new processes, different priorities among departments, conflicts with regards to roles and responsibilities, and specialist knowledge and resources on specific topics. So what is important to note is that tackling human rights due diligence might also need cultural change within your company. The next section will cover reporting on human rights and KPIs. We briefly touched upon communication, and one aspect of communication is reporting. So we want to look into that, and especially into quantitative indicators now. Companies face increasingly high requirements regarding corporate responsibility to respect human rights. In this context, many guidelines on human rights policies, risk analyses, measures, and reporting have already been developed. We saw that in the beginning of this presentation. Most of these guidelines are qualitative in nature, methodologies that allow to report on human rights in quantitative terms are less common. However, if human rights are to be at the core of corporate management and financial systems, concrete quantitative key performance indicators, KPIs, are indispensable. While acknowledging that quantitative indicators have limits, are difficult to assess, and do not replace a human rights due diligence, I'm trying to describe a set of quantitative human rights indicators relevant for companies. And here I picked a few social and employee matters that correspond to human rights. This once more illustrates that even if you haven't begun implementing responsibility for human rights under this headline, you for sure do a lot in this regard, taking into consideration social and employee matters, as you can see on the left slide. At econsense, we developed an Excel sheet that I will demo. And you can find it by clicking on the headline. This list builds on indicators drawn up by established and recognized institutions, and I will quickly run you through the spreadsheet. So on the left side, you see the list of human rights issues based on internationally recognized conventions that we already touched upon. Then you see the indication whether business activities have a high potential impact on the respective human rights issue or not. You see quantitative indicators that can be matched to the respective human rights issue. You see the respective human rights documents that you can find just by clicking on the plus sign. You find the scope of the indicator, the respective human rights indicator sources that can be found by clicking on the plus sign, and the suggestion for assessing the respective indicators. Here you find examples of human rights issues and how to translate them into the indicators, which will help you report on progress of your human rights management. And something I would like to highlight in addition is a new legislation introduced in the European Union that reorganizes non-financial reporting and elevates it to the level of financial reporting. You find the links to both the legislation and the standards on the slide. And the standards stipulate disclosure requirements and quantitative indicators for ecological, social, and governance issues. And here I picked two examples from the report, actually annual report of BMW and Bayer. The BMW example is on gender pay gap that has to be reported under this new corporate sustainability reporting law, as well as the number of fatalities and work-related accidents that you can find in the Bayer example. So if you want to get inspired by indicators for your own reporting and you feel like diving deeply into pages and pages of European legislation, I invite you to have a look into those documents. In the last section, we'll cover case studies. To wrap up, I brought two case studies that I will guide you through now. So we brought one example of workplace discrimination in own operations. So the context here, we're looking into a European technology company that is headquartered in Germany and that employs over 10,000 people. And during an internal audit, they discovered that women were consistently underrepresented in leadership roles and paid less than their male counterparts for similar the positions they held. What are the human rights issues at this point? There's workplace discrimination, violating the right to equal treatment and non-discrimination under international human rights standards, as we saw in the beginning of the presentation, and EU as well as national law. What are the deficiencies in due diligence? The company had a diversity policy but lacked effective monitoring and grievance mechanism. The employees reported bias in promotion processes, but complaints were ignored or inadequately addressed. And the consequences were a reputational damage, legal action under the EU Equal Treatment Directive, and a loss of talent and decreased employee morale. We saw that managing the transition and mitigating the adverse impacts take time, but we also saw that eventually companies that acknowledged difficulties and were transparent about their efforts were better off handling the negative consequences. Then I brought another example on employment of migrant workers in the deeper value chain, because always, and we talked about this, the risks in the deeper supply chain are often bigger than the one in their own operations. So to give you a bit of context, we're talking about a German supermarket chain that sources tomatoes from cooperatives in Southern Europe. The investigations revealed that migrant workers, primarily from North Africa, were employed under exploitative conditions. For example, excessive working hours, below minimum wage, and unsafe housing. So you see the human rights issues at this point are violating rights to fair wages, safe working conditions, and the freedom from forced labor. And the deficiencies in the due diligence measures were that the brand relied on supplier self-assessments and occasional audits, but did not conduct deeper risk analysis or engage with local NGOs to get more information. Migrant workers were excluded from grievance mechanism due to language barriers and the fear of retaliation and losing their job. And the consequences were that the NGO report triggered public backlash, that retail partners suspended contracts, and that authorities launched labor rights investigations. Thank you very much for listening. Here you find my contact details. Feel free to reach out via email or even telephone. You find the various resources and links in the presentation, and I hope those will help you guide your way through human rights due diligence.